20, State of Arkansas versus Jeremy Jessup.
Your Honor, I think Mr. Jessup is also on the September trial docket.
I have him down for November.
I get ahead of myself sometimes, Judge. I think if we're here in August, everything's going to be set in September, I guess. Your Honor, I do have a bond announcement on Mr. Jessup that he and I talked about. Mr. Etheridge and I have an agreement on bond, or at least the amount of bond.
All right.
Your Honor, his bond would now be set at $10,000, cash or pro.
The state would just request we would know where he's going to bond out to, and that he would have no contact with any of the victims in this particular situation, Your Honor.
No objection, Your Honor.
And then he requests he be required to be drug tested every Monday at probation, please, Your Honor.
Mr. Jessup, where if you bonded out, where would you be living?
I'm not sure the exact address right now. Oh man.
Well, the issue is very simple. You're accused of committing an assault on a family or household member.
I believe all those charges have been dropped.
No.
No.
Let's understand something. The state files the charges. Only the state can drop the charges. Somebody may have told you they're going to ask that those charges be dropped, but that doesn't mean they've been dropped. Once the
But if they're
charges are
fraudulent.
filed.
Okay. Yes,
Got
sir.
it? All right. So what I'm looking at is charges of burglary, residential burglary, that's a B felony. You got a couple of counts of criminal mischief, one a misdemeanor and one a felony, and assault in the second degree on a family or household member. That's a Class A misdemeanor. Now, where is it you're going to be residing? That's the
At
question.
County Road 462, Mountain Home. I believe that's the right address. I don't have no paperwork in front of me. I was living at 121 Berrywood Lane, but that's on the property.
And he cannot go back there, Your Honor, on the bond.
That's fine. I mean, I have other places to go.
All right. So the bond is conditioned upon no contact with the alleged victims in this matter. You also,
That's fine. I still have all my clothes and all my stuff there. If I do get released, can a sheriff or something drive me out there so I can get my clothes and not be in violation of my no contact?
Your Honor, those are issues, if I want to get him out of jail today. Those are issues that can be dealt with when he gets out of jail.
okay. Get out of jail. The bond is $10,000 cash for professional bond, conditioned upon no contact with the alleged victims in this matter, and you're reporting for drug testing every Monday morning at 9 o'clock. Now, those are the conditions of the bond. You'll bond out, and arrangements can be made to get you closed. I'm not going to oversee that. That'll be something you'll have to arrange once you're out.
All right.
But don't violate the conditions of the bond.
No, sir.
All right. Your next appearance in court isn't scheduled until October 31st. You need to get with your attorney as quickly as possible, as quickly as you get out. And that's actually an order of the court that you get in to see the public defender's office and make those arrangements. You understand
Okay.
that? All right. You may be excused.
All right. Thank you.
State of Arkansas versus Alicia Lewis.
Your Honor, as you will recall, last time she did not appear for court. We had an offer at that time, but she had never made an office visit, and she didn't show up here so I could discuss it with her. Now that I know where she's at, I will be down there to discuss it with her, and if we get this resolved, I will let the court know.
I would like to get it over with. I haven't heard anything from anyone. I thought Mark Cooper was my lawyer. I've tried getting a hold of him a couple times, but I don't have a phone for him to call me back. I mean, this is the first I've seen this lawyer, but I'm ready to, I mean, I've tried pleading guilty a couple times. I've just not been able to get anywhere. I would like to get it over with so
Your
I
Honor,
can
if we can
get,
transport her this afternoon, we have an offer. I can at least discuss it with her at that time and see if she wants it.
I'm gonna direct that she'll be called to transport over for the afternoon session of court, having a chance to discuss it with you and see where we are.
Okay.
Shows she still needs to be arraigned.
That's what I was trying to look through the thing to see if she's ever been arraigned on these charges.
If she hasn't been arraigned, Your Honor, we would plead not guilty to all charges.
I've been arraigned, sir, twice.
Let's see what I'm gonna determine what the record shows. Defendant is charged with a Class B felony, possession of drug paraphernalia related to Schedule 1 or 2 controlled substances. That's a Class B felony. Possession of controlled substance, 1 or 2. Class B felony, possession of controlled substance. Again, a Class D felony. Those are the 3 counts. For those charges, how does she now plead?
Not guilty to all 3, Your Honor.
I'm scheduling her on the scheduling order for trial during the week of November 18th. Putting her down for a reappearance on October 17th. And I'm directing that she'll be brought over this afternoon, potentially to at least discuss a plea.
Thank you, Your
You
Honor.
may be excused, Ms. Lewis.
Your Honor, before she's excused, I was in the background talking to somebody
Just a
else.
second.
But she has never been in, when I was representing her, she has never been in to see me. And I see people, I see a lot of people. And I resent when somebody acts like that we're ignoring them. We don't. And she's only been in jail for a short period of time. She had an appointment, she didn't keep that appointment. So it's,
I never had an appointment, and I just said I don't have a phone for you to call me back. Never did I say you didn't come see
Your
me.
Honor, I don't want to get into an argument with her. I just want to go on the record as saying, we are there to see people. I am there to see them every Wednesday afternoon. She has never been in to see me.
All right. We'll
I'll get out of jail next time to come see you. Am I done?
Yes, you are. 2016-38, State of Arkansas versus Vanessa Henschel. Is this matter for revocation today?
She has never applied to us.
Ms. Henschel, have you made any effort to secure counsel in your case?
I was out on bond and I guess we did that on the
Ms.
road.
Henschel?
She can hear you, Your Honor. She can hear you.
Do you wish to have an attorney?
No, sir.
You don't wish an attorney?
No, sir.
No.
Are you ready to go?
Yes, Your Honor, we can have a revocation hearing this afternoon on Mrs. Henschel. Ms. Henschel.
Well, then I'm gonna mark her down to be brought over. We'll take this up this afternoon. State of Arkansas versus Clay Blunt.
Your Honor, we just received some additional discovery for this file on 8/22, and as far as I can tell, we do not have an offer at this time. But do we? I'll get one before we are done with today, and I will go speak with him about that offer, or I will get it right now.
Your Honor,
Is there any possible way that I could be OR to Care Center Ministries? I have been accepted there by the Ty Carter. Is there any way that I could go there?
Well, at this point, we're in a process that's been ongoing for some time. It's supposed to resolve itself in 3 weeks or 2.5 weeks with a jury trial. At this point, I'm not going to approve an OR release, and so you need to speak to your attorney. Mr. Dennis will get down to see you. I'm setting you down for a reappearance on September 12th. Case is set for trial during the week of September 16th.
Yes, sir, I understand that. I've been here almost 4 months and not spoken to an attorney yet about any of this. I've not been granted the opportunity to have a motion of discovery or anything. And I'm just trying to get this issue resolved, sir, to plead guilty in your court of law or anything.
All right.
I have
Very
that
well, I
opportunity.
understand. You now have an attorney, Mr. Dennis, who's here in court.
Yes, sir.
And he said he's coming down to see you, so he'll get down to see you. All right?
Yes, sir. Thank you.
You bet.
Thank you, Your Honor.
Not letting me plead guilty.
No, I'm not. 2019-330, State of Arkansas versus Kyle Tilley. Mr. Tilley, do you have counsel?
No, sir.
What is your intention? Are you hiring counsel?
Yes. Public defender.
Okay. Well, you're not hiring the public defender's office. They get appointed to you, but I understand.
Yeah.
Have you filled out an application for the public defender's office?
Yes, sir.
You all haven't received it yet? When did you fill that out?
I just did it today.
So have you turned it in?
Yes, sir.
You know, we were there this morning, we didn't get it. Your Honor, once he turns it in, the court will recall, I think it was 2 weeks ago that we pled him out on a series of cases, so nothing has changed in 2 weeks, so we'll be appointed again, I'm certain.
Okay. On the allegation of theft by receiving, it's a Class D felony. How's the defendant now plead?
Not guilty.
A plea of not guilty is noted on the record. The court is setting this matter down for trial during the week of November 18th. A reappearance would be on October 31st. I think we got the wrong
Change.
So your next appearance in court will be October 31st. Mr. Tilley, you've been through this system before. The public defender's office will be down to see you and meet with you. And if you bond out, it's your obligation to get in touch and stay in touch with the public defender's office. If you were to bond out, you need to know that the very first thing you should do after getting out is to make contact with the public defender's office and get in to see. Do you have any additional questions?
No, sir.
All right, you may be excused. State of Arkansas versus Wayne Smith. There were also cases of 2019-19, 2018-402 involving the same defendant.
Your Honor, on case numbers 1919 and 18402, Mr. Smith is representing our office. On his newest case that he's being arraigned on today, we do not have an application on him yet.
Mr. Smith, if you could hear Mr.
Oh,
Cooper speaking, you'll need to fill out a new application for the public defender's office if you want representation from the public defender's office. Confident you understand the process, you've been through the process before. You're charged with possession of drug paraphernalia, a Class D felony, and then a separate count of drug possession of drug paraphernalia that's a Class A misdemeanor. Then driving on a suspended license. Carolyn careless and prohibited driving, 2 counts. Those are the charges against you. On those charges, how do you now plead?
I'm not guilty of any of this crap, Your
All
Honor.
right, I'm noting your plea of not guilty. If you want representation in the public defender's office, you're gonna have to apply for it on this new charge.
Well, sir, I've had every public defender has been appointed to my case at some point or another. And I prefer to have Cody Dennis as my lawyer. And
That's who he has, Judge.
Here's who he's got.
I believe him already as attorney, Your Honor, but 1919, we do not have discovery on yet. We did have an offer on the other one he's not being arraigned on yet. And he has turned down that offer, so I'm trying to get a wrap-up offer worked out for the other 2. But
2019 338, it's just been arraigned on. I'm setting that on the trial schedule for November, the week of November 18th with a reappearance on October 17th. I'm going to set down these other ones. I think already have scheduling orders.
They do, Your Honor.
Let me see where they are. 2019, I think has been transferred to the Division 4 docket. No, it's on the Division 3 docket, set for trial during the week of September 23rd, is what's listed on.
Thought that was correct, Your Honor.
Your Honor, we would ask that that be transferred to Division 4 as well, to keep them all in the same division.
Your Honor, the state would not want that to happen. We would like it left just like it is, Your Honor. We have a reason
Your
for
Honor.
that.
David Etheridge is a personal friend of my sister who I have called the name and she's mad at me. Her name is Debbie Smith. She's a retired lawyer. She and David Etheridge, I believe, have daily telephone conversations. I think this is wrong. I feel like I have been railroaded from day one by Debbie Smith, who I called a stupid. I think that is wrong.
Why don't you just cut it short there, and you need to talk to your attorney about these matters.
I would ask for.
I'm leaving your case on for trial the week of September 23rd in front of Judge Putnam.
Asking for a bond reduction. Not fair.
Your bond is in the process, has been revoked, and I'm not reducing your bond.
What is my bond?
Well, I don't think you have one at this point, because I think your bond on your other 2 cases has been revoked.
He got 2 new cases.
So you don't have a bond.
Yeah, so they're both just bond on them 2 because of that.
Okay, she was saying something about Bayless might be an attorney.
Your Honor,
Was at one time, yeah. So.
I'm not a flight risk. I've lived here all my life. I'm a retired postal worker. I don't cause any problems. Not a dope quit. Feel like I'm being railroaded. Feel like, if anything, I should be
What I want you to
let
do,
loose
you've
my
got,
own recognizance.
you've got an attorney. You need to discuss this with your attorney. All right?
How can I do that if I'm in jail?
Because your attorney will come to see you in jail. That's how you do it. Did you get in to see your attorney when you weren't in jail?
I didn't have one then, I didn't need one.
You've been on the docket for quite some time.
Yeah, because of nonsense.
Well, If it's nonsense, I'm sure your attorney, who's a very capable individual, will determine that and present that to the court. So, at this time, this is where we are. The case is on, is scheduled. Who's been representing you to this point in that, under Judge Putnam? Huh?
I think Sam has your honor.
So Mr. Pasty is your attorney in case 2019-19, and that's the one that's set for trial in front of Judge Putnam.
What's the charge?
Have you not been in to see Mr. Pasty and talk to him about it?
Hell no.
Okay. Well then that's your fault.
No, it isn't.
Yes, it is. If you're getting court-appointed attorney, you can do, the least thing you can do is show up in his office and talk to him. And that's your responsibility. So if you haven't talked to him, then that's your fault. You're getting an attorney provided at the expense of the taxpayers. And the least you can do is get in to see him.
On charges of nonsense.
What the charges are in that case are possession with the purpose to deliver methamphetamine, Class B felony, possession with the purpose to deliver
All nonsense.
Class C felony, possession of drug paraphernalia, 1 count B felony and 1 count D felony. Those are the charges in the case that I'm talking about now, 2019-19. Now,
Your Honor, I shook your hand
if you
on it.
aren't smart
Hey.
enough to get in to see your attorney, who's been provided for you at no expense to you, then you need to understand that that's irresponsible on your part, and you don't have any reason to complain about either your attorney or the way you're being treated in the court.
Well, that's your opinion. I
Yes, it
shook
is.
your hand on the first day you came into being a judge in the Baxter County Courthouse.
Well, all well and good.
Well, all well and good, yes, sir. And there's no reason for me to be here. You want to tell me that it's my fault I did everything. I'm saying I'm not guilty, I shouldn't be here.
Mr. Smith, we're done here today. You're in
We are.
jail, you're
Yes,
bonded, you don't have a bond at this point.